Thank you. Welcome to the Heritage Foundation and our annual Supreme Court Roundup. We have three panelists today, a practitioner, a professor, and a journalist to give us a diversity of perspectives. If you please welcome them onto the stage with me, and I'll give them very brief introductions. So I'm going to have to give, in the interest of time, to maximize the amount of time we get to hear from them, I have to give them all much shorter introductions than they deserve. To my right, our practitioner, David Thompson, is the managing partner of Cooper & Kirk. His extensive trial and appellate experience in more than 30 district courts, every single federal circuit court of appeal, and the Supreme Court. To his right, our professor, Josh Blackman, is a professor of law and Centennial Chair of Constitutional Law at South Texas College of Law in Houston, is a prolific author of books, law reviews, and commentary, frequently blogging at The Volokh Conspiracy. He is also president of the Harlan Institute and founder of Fantasy SCOTUS. And last but certainly not least, our journalist, Kalen Deese, is a reporter for the Washington Examiner, where he covered the Supreme Court until his recent pivot to the Department of Justice. He previously served as a breaking news reporter for The Hill. So I want to start our talk today on what's often called the emergency docket. These are the cases that rush up to the Supreme Court on not on writs for certiorari, but on various emergency bases. This has been a source of a great deal of cases and opinions this term. So I just want to sort of kick it open. Let's start with you, Kalen. Give us an overview of what's going on the emergency docket and why it was such a big thing this term.
Thanks for that introduction, Giancarlo. And just wanted to say that, typically I think the emergency docket isn't something that we would start with in a type of panel like this, but I think this term saw an outsized interest in the way that the court works on this docket, and particularly over the subject of immigration, deportation policy. And I think that you can really sort of pinpoint the interest that, really developed from the public's perspective when it came to the March 15th decision for Donald Trump to invoke the Alien Enemies Act. That was something that I sort of described as planes, alien enemies, and out-of-control judges. So that was something that we saw immediately, a fight that started in the D.C. court over the Judge Boasberg, who issued a temporary restraining order to halt removal of around 260 Venezuelans to El Salvador. And that happened obviously while the flights were taking off, and that caused a bit of a pickle for the administration and for the courts. Well, fast forward ahead to the fact that there wasn't really anything that could be done to return these migrants. On April 7th, there was a case that was brought by the ACLU that made its way to the Supreme Court, and it vacated Boasberg's order under a per curiam decision, holding that any challenges must be filed in the district where detainees are held, not in D.C., and that they must come in the form of habeas corpus petitions. And the court didn't really decide, anything beyond that, whether the deportations were lawful. And it sort of set us up for this round two that I call the Alien Enemies Act round two, Saturday morning blues, because there was a bit of a, late night decision that came, in the subsequent, weeks after the ACLU filed in multiple jurisdictions, across Texas, across Pennsylvania, New York. There was a case that arose from Texas up to the Supreme Court, and it was around 1 a.m. on April 19th, and the WMM versus Trump case, formerly the AARP case, that was, aptly renamed so that there wouldn't be any, confusion with the actual AARP. And the Supreme Court issued a temporary pause on the deportation of a group of Venezuelan migrants to El Salvador. And that was sort of seen as especially by justices like Samuel Alito, Clarence Thomas, you didn't offer us, you didn't offer the government any, apt time to actually give a response. And before you issued this decision, that was sort of in response to what the majority held there. And it even brought this dissent from Justice Alito, where he said, both the executive and the judiciary have an obligation to follow the law. He went forth to say the only papers before this court were those submitted by the applicants, ACLU, and the court had not ordered or received a response by the government regarding either the applicant's factual allegations or any legal issues present in this case. That was sort of a stern dissent that I think got a lot of people's attention again, because it sort of ignited this focus on how the lower courts were just issuing injunction after injunction, and what are we going to do about this? Well, I think my colleague here, Josh Blackman's going to talk about that here in a moment. But just to kind of put a sort of finer point on everything that's happened, on May 16th, the court issued a follow-up that remanded the case back to the Fifth Circuit, the one we're talking about here, the Alien Enemies Act Round 2, and instructed the appellate panel to determine whether the detainees have been given adequate opportunity to challenge their removals. And we've seen that case now already go to the Fifth Circuit panel on June 30th. It kind of seemed like the panel, I'm not going to read too many tea leaves, but it kind of seemed like, from my perspective, that the panel was leaning towards siding with the Trump administration, although that doesn't guarantee what's going to happen in the end whenever this rises up to the Supreme Court inevitably again. But to get to one last position that the Supreme Court took recently here on the emergency docket that I thought was good for them to address, at least in the interim, they ruled on May 30th that the Department of Homeland Security could proceed with revoking parole and work authorization for about 500,000 migrants from Cuba, Haiti, Nicaragua, and Venezuela. Now, that was seen as a win for the Trump administration and its efforts to sort of roll back those past administration policies. And one other decision recently, I think, that was very significant and sort of the finer point on this first half of the year's immigration shadow docket was the DVD case versus DHS, which permitted the deportation, we just saw this last weekend, of 8 criminal migrants, to South Sudan. And that was something that was, for lack of better words, that the Trump administration was trying to really accomplish with its third country removal efforts. And so we'll see from there where that effort takes in lower courts. So
playing into the issue, I think our mics have... No mics, they've cut off. So I'll just talk loud.
Sorry, Zoom.
Actually, I see a handheld. Oh, no, there I'm back. And we'll just get this handheld here for in case anybody else's cuts out. But playing into the issue of the emergency docket and emergency appeals is the issue of nationwide injunctions, which the court tackled in Casa, Trump versus Casa. Josh, you want to give us an overview of that case?
Sure. Can you hear me? Good. Nationwide injunctions are the things you love when you're out of power. And when you're in power, you hate the nationwide injunction. It seems every 4 to 8 years, people flip. During the Obama administration, conservatives loved it. And then during the Trump administration, liberals loved it. And then during Biden, everything flipped and flipped again. The Supreme Court has dragged their feet on this for nearly a decade, if you can believe it. Even Justice Scalia was around when we were talking about these issues. Over the years, Justice Thomas and Justice Gorsuch have said these are wrong. Justice Kagan, for a while, said they're wrong. Maybe she changed her mind, I don't know. But the issue really came to a head in the most unlikely case, Casa. President Trump on day one issued an order that would deny certain documents to the children of illegal aliens. That is, these children are not going to be citizens by birth. It was prospective. It wouldn't be stripping people of citizenship. It was prospective. Within minutes, I'm not exaggerating, within minutes, judges enjoined these orders. They probably didn't even read the complaint. They just said, okay, Trump, enjoin, national injunction. And the orders were not limited to the parties before them or even the states that brought these suits. They applied to everyone around the world. Doesn't matter who you are. It was basically a universal injunction. Trump lost in virtually every lower court proceeding, and then they went to the Supreme Court. But they made a decision. They didn't ask the Supreme Court to review the merits, that is, what does the 14th Amendment mean? Instead, the SG asked the court to rule on the nationwide injunction issue. They said, look, we will agree to an injunction for the people who are named, the named parties, but we want to vacate these global injunctions. The court heard oral argument on a fairly expedited basis, and they decided it on the basically last day of the term. It was a decision by Justice Barrett, a 6-3 decision. And the big highlight item is no universal injunctions. Right? That was the bottom line. Why? It was a historically grounded opinion. There was a decision from Justice Scalia called Grupo Mexicano, which said the courts of equity in Old England, that should inform what our equitable powers are in modern times, unless Congress intervenes. At common law, there was no such thing as universal injunction. There were bills of equity, but they involved the parties before the court. Justice Barrett said also, just because you need to give complete relief doesn't mean you need to give relief to everyone everywhere. There was a vigorous dissent, which said, no, yes, this is authorized, but this issue I think is now settled. The rub, though, is what the court sort of left open. The court left open the issues of states and whether there could be a statewide injunction. They didn't quite settle that because it wasn't presented below. That's number one. Number two is the issue of the class action. Rule 23, as everyone knows from civil procedure, allows the court to certify classes. These classes, if there's enough commonality, can be quite broad. The court didn't decide that issue. In fact, Justice Kavanaugh suggested that even if you don't have a universal injunction, maybe you can have a class of all pregnant illegal alien mothers, right? I mean, that's the class, in which case it would be effectively a universal injunction. As we speak, lower courts are trying to craft those remedies. There's a third issue that's sort of lingering, which is the set-aside, the vacatur. Under the Administrative Procedure Act, the federal courts, especially in DC, somewhere over there, have long said that we can basically set aside rules. We can set aside executive actions. What does that mean? It's vacated. It's gone universally. The arguments against the national injunction, I think, apply with equal force to vacatur as a matter of first principles, but Chief Justice Roberts, Justice Kavanaugh, they are products of the DC Circuit. They issued those 5 times before breakfast, as Roberts once said. So I don't know that they're willing to kill the vacatur. And if they do, they create an asymmetry. That is, if you file suit in the DC Circuit, you get your relief. If you file suit in the Fifth Circuit on a national injunction, you probably don't. And we see who that hurts and who that harms. So I don't know how big of a ruling CASA will be in like 5 years. I think judges will just pivot to certifying classes on the fly, like Judge Boasberg did in the airplane case, and say, okay, we're not issuing a national injunction, we're issuing a nationwide class, and I'm certifying it, congratulations. So this seems like a huge victory for Trump. It feels like it now. We'll see in a short period how this actually shakes out.
David, I want to invite you to offer any of your own thoughts on the emergency docket before we move into other merits.
No, I think it's been covered very well. One of the things that you can look at our statistics as to how many cases the United States Supreme Court is taking a term. And of course, when the liberals were reigning supreme, they were taking hundreds of cases a year. And I think some of us are a bit disappointed that now that we have a working majority, we're taking 60 cases a year or so, really a historic low. And I think one of the answers our friends would tell us on First Street is, well, we're pretty busy, and we're busy with these, so-called shadow docket expedited proceedings, and that's a fair point. It is. We're going to hear about the TikTok case that was done on a very expedited basis, and the CASA case as well. So I think we do need to keep that into account when we look at the workload up there. They're not just playing golf every weekend.
So moving into merits, Kaylin, can you start us off with Scrimetti, and then David, you can talk about the Thomas concurrence in that case, if you wouldn't mind.
Yeah, absolutely. Well, the Scrimetti decision was arguably, I think, the most anticipated merits docket decision that people were wanting to see this year. We're wanting to find out what exactly was going to happen with Tennessee's SB 1, which makes it to where children under 18 cannot undergo these transgender medical procedures, or what some would call mutilation as well. So on June 18th, the court issued a 6-3 holding that upheld Tennessee's SB 1. And Justice Roberts wrote this majority, which held that the law does not classify based on sex or transgender status and is subject to rational basis review. And that is the most deferential constitutional standard. So it was a really big win for Tennessee and states like it that have laws that protect minors from these types of procedures. And it really was something that I think, as far as from a state standpoint, gave a lot of leeway for states that want to create, copies and things of that sort, mirror Tennessee's law. The one thing I thought that was interesting, and I think a lot of people were, anticipating after the oral arguments, is that Scrimetti notably did not address if the court's 2020 decision in Bostock applies outside of the hiring and firing context, governed by Title VII, and whether transgender people are a quasi-suspect class. Suspect, being, strict scrutiny applies, and quasi is more of an intermediate scrutiny when it comes to cases handling those subjects. I thought it was interesting, that we saw Justice Barrett joined Justice Thomas and emphasized that in the context of SB1, transgender status doesn't qualify as a suspect or quasi-suspect class because the law involves those under 18 or people who are minors. I think that was a very good thing to bring up and to notice because it sort of creates this, I would call like ironclad way of thinking about this rather than getting into the more thorny issue, which would be what I was just mentioning about how do we define suspect, quasi-suspect. But notably, though, I think that Alito's concurrence sort of gives, a little bit of a window into what the Supreme Court, at least some of the members in his case, could hold in a future case that actually maybe needs to get into the more gritty nature about that suspect, designation, because he said he would have held that, transgender individuals are not a quasi-suspect class, which is pretty interesting to sort of get that perspective, at least from one of the justices. Now, a lot of people wanted to know what would be the immediate impacts of the Scrimetti decision. And as we saw on the following Monday after it was decided, there was at least a few cases there in North Carolina, Idaho, and West Virginia where we saw where similar laws had been blocked previously by lower courts. Those were remanded. So there's going to be, more reconsideration, and it looks like, that anywhere that, states had similar laws that were blocked, there's going to be a lot of, reconsideration, and, hopefully those states will be able to uphold their laws. And I just wanted to touch, very briefly, because I actually had, the privilege of talking to General Scrimetti a couple weeks ago. I think it was last week. All the weeks are running together right now. But I think that it was interesting because he offered an interesting perspective to me where, he was saying that he was astonished, honestly, that the Supreme Court even took up his case there out of Tennessee. He didn't think it would be something that the court would particularly want to touch. And I asked him, if he thought there was going to be any other types of, transgender, Title IX-esque equal protection clause cases in the future. He told me, he highly doubts it. Well, it just so happened that like 1 or 2 days after he said that, the Supreme Court decided that they were going to take up one of the most very particularly high interest issues when it comes to males competing in girls' sports. And that was something that took a lot of people by shock because the Supreme Court had on multiple occasions dodged opportunities to weigh into the issue of Title IX and Equal Protection Clause issues surrounding males participating in girls' sports. But we're going to see an argument on that question next term, and I think that could potentially sort of tee things up as the next big culture issue that people will be really paying attention to at the Supreme Court next year. There's a couple other ones that will touch on hot button issues, but that particularly in the cases West Virginia versus BPJ and Little v. Hecox is, they're going to be very noteworthy to watch.
David, Justice Thomas had an interesting concurrence in that opinion, which I think you may have had some hand in.
Yes, that's right. Justice Thomas had a separate concurrence where he talked about the allegedly settled science. Dozens of medical groups, including all the leading medical groups in the United States, had intoned the science is settled. And indeed, it is settled because the risks are many, and they are known, and they are certain to children who are subject to genital mutilation, cross-sex hormones, and puberty blockers. Those risks include sterilization, loss of bone density, and loss of mental cognition. Justice Thomas pointed to the NHS, not exactly known as a hotbed of conservatism, which recently concluded that there was essentially no evidence to suggest that these treatments were safe. He also pointed to and quoted at length from some documents from WPATH, the left-wing, radical, transgender, but I repeat myself, group that claims they are the world's leading expert in the science. And these were documents that the state of Alabama and our firm obtained in discovery, and I'll just read from a few of them. One of these so-called experts at WPATH said, quote, "Our concern is that evidence-based research reveals little or no evidence and puts us in an untenable position in terms of winning lawsuits." Here's a spoiler alert, or a tell. When scientists start, worrying about evidence-based research, they're on very thin ice. Another person said in an internal email, it was ethically justifiable to advocate for language changes to strengthen our position in court. And internal emails from WPATH pointed out that a senior Biden administration official, quote, pressed us to remove age limits for adolescent surgeries from guidelines for care of transgender minors on the theory that specific listing of ages under 18 will result in devastating legislation for trans care. So Justice Thomas concluded that the views of self-proclaimed experts do not shed any light on the meaning of the Constitution, and thank God for that. And I think that's a leitmotif of my career, is looking at all these left-wing academics who come in and say, this topic is settled, it's beyond debate, how dare you even have the temerity to suggest that we're not right, and they're almost always wrong when they say something like this. Now, where does this leave us in this fight? I have been telling my colleagues, this is a play in two acts. There's a red state act and there is a blue state act. And we have now, with the thanks of the United States Supreme Court and General Scribes, we have protected children in 27 states from these terrible medical procedures. What about the children? Yes, it is very exciting. What about the children in the 23 blue states? What are we going to do for them? Medical malpractice lawsuits, a tsunami of litigation is going to sweep over the medical community, and they are going to pay a severe price for what they are doing to these children. So that's coming to a theater near you.
David, can you continue the discussion with the Mahmoud case?
Oh yes, Mahmoud. This is a case out of Montgomery County, and Montgomery County looked at all the challenges facing children in America and decided what 5-year-olds really need is a steady dose of LGBT-friendly books. Why did the groomers in Montgomery County decide to try to force feed 5-year-olds with this radical left-wing gender ideology? They tell us in internal emails they wanted to, quote, disrupt the heteronormative views of 5-year-olds. And so they unfurled this program. And in the beginning, they had an opt-out provision. They would tell parents, hey, we're gonna have this book, Bobby has 4 daddies or whatever, the next day, and then parents could opt out. There was a problem. Almost all the parents stopped opting out. This was a problem for the social engineering experiment. So Montgomery County doubled down and said, no more opt-outs, no more notice, no more opt-outs, and that case came to the United States Supreme Court. So how bad are these books? Well, here are a few spoilers. Prince and Knight is about a prince and a knight that get married. Now you might think, of course, the book must have had conscientious objectors, quoting Pope Leo, that marriage can only be between a man and a woman on placards. No, that was not in this book. Instead, everybody Everybody in the kingdom celebrated this union. There was Love Violet, about a girl who had a crush on a classmate, and they end up holding hands and their hearts beat at the pace of 100 galloping horses. There was Born Ready, featuring Penelope, who is a girl but claims she's a boy. And when her younger brother says, and suggests that biological sex is an immutable characteristic, that's a paraphrase, the mother says, not everything needs to make sense. This is about love. Okay, and then if there was any, worry about, well, what are they really trying to get at? They had a discussion guide, and in the discussion guide, the teachers were instructed to say, quote, at any point in your life, even when I'm 5, yes, at any point in your life, you can choose to be any gender or no gender or multiple genders. And then in bold in the discussion guide, it said, what pronouns fit you best? This is for 5-year-olds. So the United States Supreme Court analyzed this from the perspective of parents. Now, footnote, I think it would have been interesting if it had also been analyzed from the perspective of children. That wasn't a claim that was brought, but I think children have a right to be free, even if their parents are deranged and don't opt them out, to be free from sort of harmful left-wing radical gender ideology. But leaving that to the side, the Supreme Court said that certainly parents have for a long time been understood to have the responsibility for the religious upbringing of their children. They said that this substantially interfered with the religious upbringing of the children and therefore was invalid. The dissents said, well, this is just exposure to the fact that LGBT people exist. And Justice Alito said, look at the context, look at these books, they have a clear message, and you're just whitewashing the message. In dissent, Justice Sotomayor opted for understatement. She said public school benefits would be, quote, a mere memory, close quote, if this decision went into effect, and that, quote, chaos would ensue. I think we'd be able to look across the country. Is there any chaos ensuing from this? I don't think there will be. The dissent was really very weak and mostly just, sort of shouting that the sky was falling. So it was an important decision, and the Fourth Circuit beclowned itself once again and has been slapped down.
All right, from gender, we move into guns. Josh Vanderstock, if you would.
Why do there's a Vanderstock?
What's that?
Okay, well, this was David's case, but I'm talking about it. So Vanderstock is a case about, quote, ghost guns. Now, I don't like that term, ghost spooky, right? It's meant to scare people. There has been for decades a community in this country that has liked to build their own guns. These are not criminals, these are not terrorists, these are not assassins, these are good, law-abiding Americans who like to tinker with guns, the same people like to tinker with, Legos or cars or little figurines. People like things. I've never built a gun. Dave, have you ever built a gun? No. I don't actually have any dexterity. I would not do this well, but people do it. For the longest time, our friends at the ATF have said, if you get a kit that is approximately 80% complete and you finish off the last 20%, that's fine. You've not acquired a firearm, you built it for yourself. There's no background check, there's no forms, you can do that yourself. But fairly recently, ATF reversed course. They said, aha, that if you have these effectively blocks of metal that could be converted into a firearm, that is actually a firearm. And it must go through all the hoops and hoopla of regulating guns in America. Now, in fairness, I am one of the lawyers in this case, as is David. I represent Defense Distributed. Dave represents some people who actually built these guns, and we filed a lawsuit. The district court agreed with us. The Fifth Circuit agreed with us. You know what's going to happen, right? The Supreme Court will reverse. This case was argued earlier in the term, and for the argument, it seemed pretty clear that we probably weren't going to win. One of the highlights or lowlights, that's how I phrase it, of the argument was Chief Justice Roberts said, why would someone want to do this? It's not like fixing a car in your garage. These are just criminals, right? And I was kind of insulted by that because we have Jennifer Vanderstock, who was sitting in the courtroom, and she was saying, hi, Chief, I'm here. I'm not a criminal. Was she a teacher, I think? She's a teacher who likes to tinker with guns. I think the government, and S.G. Prelogger was quite good, made this out to be a bunch of terrorists trying to use these kids to make guns. But the court accepted that rationale. We have a dissent from Justice Thomas, a dissent from Justice Alito, so it was pretty lopsided. I think what was even more sort of striking about this case was how the court accepted the rationale of the government, and they didn't closely scrutinize how for a long period of time people have been allowed to do this. One of Justice Kavanaugh's hallmarks is tradition, right? Tradition. And if you look at how these laws have been enforced for years, the government changed course. And it's obvious they changed course. Why? Because they couldn't get gun control legislation through the courts. So I think this is a tricky decision. It sort of follows a surprise victory last year in Cargill about bump stocks. But this is not a great case for admin law. I think there's actually some pretty harmful language of how to bring challenges to federal regulations. If you read the opinion carefully enough, you have to be really, really sure before you declare a regulation unlawful, right? This actually makes it harder to bring challenges. So I don't know why the court went down this road. They did, but I'll let you know the case is actually still not dead. They didn't resolve all the claims. There's some ongoing litigation right now in the Northern District of Texas. So that case is sort of ongoing. But Vanderstock, not a great case. That stung a bit when we saw the opinion. We knew we were going to lose, but the opinion itself stung pretty bad. Dave, do you want to add anything to that?
I agree. That's a good summary.
Could I ask a question?
Of course.
I'm just wanting to know, what do you think is kind of the main distinction that changed between where the court was leaning in Cargill versus in Vanderstock? What kind of
I do think the left did a good job of demonizing these firearms, calling them ghost guns, claiming that there was a sharp increase, which was solely attributable to the fact that Biden started making people start tracking these things. So, okay, if you're required to start tracking them, you're going to see more of them. Yeah. But I think they did an effective job of creating this impression that this was a real public safety crisis. And obviously, conservatives on the court care about public safety. And so they converted this case into that, which is really not fair.
Yeah, I'll make one last point. S.G. Prelogger said she actually built one of these. She didn't say she ever tried to fire it. So it's easy enough to just drill some holes, but it actually work. These are things that are hard to make. I've actually talked to people, you need exquisite skill to do this correctly. And also, to the marketing point, she said, oh, this is just like you drill a few holes here, punch through, tear a plastic tab there. This is not IKEA. This is very complex machinery. And I think the marketing campaign really sold the case, unfortunately.
Yeah, I mean, I can barely tie my shoes, but my brother, my brother's very mechanical, so I asked him to build one of these, and it took him 3 days, a day to study online, a day to find the parts online, and then 8 hours of machining with it. And at the end of it, he said, I'm not going to fire it because it would be too dangerous to fire it. I could lose my hand. So you really have to have an expertise, even if you're to actually make one of these things. Yeah.
Kaylin, can I pitch over to you for the Catholic Charities case?
Absolutely. This is an interesting case, another sort of building on the court's holdings that have really affirmed religious freedom in the last decade around that period. And it's also a 9-0 written by Justice Sonia Sotomayor overturning the Wisconsin Supreme Court's decision. So we know that if Sotomayor is overturning that court, then we can call it perhaps a bench slap by the liberal-appointed justice. So on May 30th, the Supreme Court issued that unanimous decision in favor of the Catholic Charities Bureau, and it was a nonprofit. That's a nonprofit under the control of the Diocese of Superior, Wisconsin. And that case was challenging the state's denial of a religious exemption from unemployment insurance taxes. And the state made the argument that the charities work wasn't primarily religious because it served the people and it did not evangelize. And that was a huge problem because, the Catholic Church, does works. I mean, that's the problem that Sonia Sotomayor pointed out, and she rejected the reasoning that the state and the state Supreme Court were making, and saying that the First Amendment prohibits courts from second-guessing how faith is expressed. And she explained that the charitable service is core religious expression. And the penalizing a ministry for not proselytizing amounts to a denominational preference in violation of the religion clauses. Not only was this such an egregious decision from the Wisconsin Supreme Court, but it also really flew in the face of two recent, in the last, between 2000 and now, decisions from the Supreme Court that really weren't too dissimilar from this Catholic Charities case. In 2020, there's a case known as Our Lady of Guadalupe school, which affirmed the ministerial exception in the religion clauses. And likewise, there's a 2012 case that affirmed the civil authorities may not interfere with internal governments from religious organizations. One of the things, again, about this decision that was so great is that, it gave us a chance to see where the court is finding agreement on all things. And it also included some notable concurrences. I like the one from Justice Clarence Thomas, whenever he sort of honed in on this, church autonomy. He said, and I quote, "The First Amendment guarantees to religious institutions broad autonomy to conduct their internal affairs and govern themselves. This guarantee, which we have called the Church Autonomy Doctrine, provides that a religious institution is not defined by corporate entities it chooses to form." That is the core essence of this case. I think it will, really continue to be, for this court. I think that, the Roberts Court will be defined by its adherence to, First Amendment religious freedom whenever people go back and write about it years and years from now, because it seems like, especially in recent time, year after year, we've seen this court be very willing to take up some of these cases, and they're not always 9-0. I know that there was that, praying football coach case a couple years ago that, wasn't something that I think got complete unanimity on, but, on other matters like, praying on, or not praying on the Sabbath, but working on the Sabbath, religious exemptions to working on the Sabbath, I think that's, been something that the court's been in large agreement on. So we'll continue to see more of these cases. I don't know, we can say that the court's, ever necessarily done in this category, because, across different states, there's all these very strange, weird statutes that you might find. I know that there's, some databases out there where you can go and, do research yourself about states that have antiquated laws that are essentially an affront to religious freedom and rights, here in our country. So definitely, I think the court will continue to take more of these cases.
David, can you tell us about Free Speech Coalition versus Paxton?
Yes, this was a case which involved the question of whether children should have access to pornography. And as you can imagine, it was a sharply divided court, 6-3, with the usual suspects dissenting. Justice Thomas, his majority opinion, addressed Texas's law requiring age verification. You had to be 18 and prove that you were 18. So it wasn't a Maginot Line age limit. You actually would have to prove that you were 18. And most of the fighting between the majority and the dissent is over the level of scrutiny. Would it be strict scrutiny, in which case you'd have to have a compelling governmental interest, and also, more importantly, it would have to be the least restrictive means possible, or is it mere intermediate scrutiny, in which case it would just have to be an important governmental interest that was substantially related to that interest. And Justice Thomas had a pretty easy time saying it's intermediate scrutiny. He started by pointing out that as a matter of history, there are whole categories of speech that are not protected at all by the First Amendment. You have fraud, you have incitement, criminal conspiracy, and obscenity. And he pointed out that states absolutely have the right to keep obscene materials out of the hands of children. He said, once you agree on that, it necessarily follows that states have to have the ability to effectuate that policy. And he looked at this law, and he said, age verifications, he said, these are pretty common. We have it for alcohol, we have it for tobacco. Justice Thomas tells us, I don't know this on personal knowledge, body piercings. All of this, require age verification. He applied intermediate scrutiny. He said, is this an important interest? Of course. Is it substantially related? Yes, it is. Now, Justice Kagan, in dissent, seemed very concerned about the chilling effect on pornography consumption in America. She credited the fact that it was a compelling governmental interest to keep it out of the hands of children, but she wasn't certain that Texas might not have been able to do, a less restrictive alternative. They hadn't proven to her satisfaction that, there wasn't some porn consumer out there who had been deprived of his or her ability to access this material. And so she dissented. Obviously, those arguments were completely unmoving to the majority. So they made pretty short work of it, but it's, I think, an important, it's going to have important practical consequences, because in some of these states, it turns out that some consumers of porn are a little less eager to do that if they have to put in their government ID into the internet. And so it's had a really salutary effect in the states that have passed these laws, and I think you'll see more of them.
Josh, the TikTok case
Yeah.
and subsequent developments.
Yeah. So who here has TikTok on their phone?
Oh, this is very
You can
troubling.
leave. The door's over there. Good. Heritage. Good. So TikTok is one of these weird cases that was really big and then was decided and then didn't matter at all. Congress, in a bipartisan act, passed a law that would effectively ban the Chinese-owned TikTok from American devices. Okay? Again, bipartisan act. We don't do that very often. I think Congress recognized that it's a bad idea to have millions of Americans with an app controlled by the Chinese government on their phones, uploading their most sensitive information to some cloud. Okay? TikTok brought litigation. They argued this was a First Amendment violation. This was a violation of the Bill of Attainder clause, which doesn't come up very often. The DC Circuit, again, this case sort of began right in the DC Circuit, effectively argued that this is a way of saving Americans from being affected by foreign adversaries. So even if there's some First Amendment interest at play, the government's interest is compelling enough to justify this restriction of speech. This went to the Supreme Court on an expedited oral argument. It was argued in January, and they had to decide this in a span of like 2 weeks. Why? The law was going to effect on January 19th, the day before the inauguration. So the court decides this about a week before. They say, this law is constitutional. You have a per curiam opinion. The court disagrees over a few things, for example, about what is the right level of scrutiny and whether it triggers heightened scrutiny, but they uphold it. But what's curious is that right before Biden leaves office, before he issued all those other pardons, he also issued an executive order saying, I will not enforce this law during the last 24 hours. So the court upheld the law, then Biden says, I will not enforce it. Then Trump comes to office and he says, I'm not going to enforce it either. And here we are, 5 months since the inauguration, the law has not been enforced. And in fact, General Bondi put out a letter to the tech companies saying, we will not enforce this law. And you will not be liable if you allow TikTok on your device. So my friend over there, it's okay. You are not triggering liability. You're fine. This is a very strange case because it implicates free speech on the front end. Okay, that's resolved by the court. But now we have what's called the power to not enforce statutes. Now, if you've been around the block a bit, you'll remember something called DAPA. Right? This is President Obama's immigration policy, and DACA. For much of the administration, they didn't enforce immigration laws. They didn't enforce controlled substance laws. They didn't enforce Obamacare laws. I can go on for hours on this topic. And it was, okay, that's fine, that's cool. And now that Trump is saying, okay, I'm going to use my discretion to not enforce the TikTok law because, oh my God, rule of law is a king, dispensing power, take care clause, et cetera. So I think what we're seeing right now is this kind of this culmination of so many different realities of how to look at executive power, where when previous presidents do it, okay, that's cool. And when Trump does it, okay, that's the end of the world. But I think TikTok will remain on your phones. It seems like Trump is trying to make there's always a deal. He's trying to make some kind of deal to get the Chinese to sell this company to an American entity. And if so, this case will be forgotten. So I talked about it. It's here, and probably won't matter much more next week.
Well, I think it was the end of the world when Obama did not enforce the drug laws in this country and allowed marijuana to sweep like a plague and a cancer across the country, even though it remains today a federal felony in every state. And I think this is of a piece with that. I think it is very hard for us to say, well, we're rule of law conservatives, and to have this law that is absolutely should be in force or effect and is not being enforced. So I think it's unfortunate. It's very pernicious, and I hope that it is enforced. Unfortunately, I have thought long and hard: is there someone with Article 3 standing who could bring a challenge? And the law was crafted in a way that really deprives anyone of an ability to bring suit to enforce it, which is too bad.
So I wanted to ask just real quick on this. So if the standing issue is a problem to bring a lawsuit, what happens if a deal never sees the light of day? I mean, that's just
That was the issue. Here's the thing with non-enforcement, standing is very hard because no one's being injured by it. We saw this with immigration. If you don't enforce immigration laws, who's injured? Well, Texas says, well, we have to print driver's license for these aliens. Okay, that's creative, but that's unusual. Unless you have an entity injured by the policy, the courts can't resolve it. That's why non-enforcement is so dangerous.
Well, but I represent 10 states suing TikTok. We like to say at Cooper and Kirk, Carthage must be destroyed, and by that we mean TikTok. And social media. So there's plenty of harm. There's an amazing amount of harm flowing from these companies, and they're addicting children and filling their heads with filth while they lie to consumers about it. So there's a lot of harm. The problem is, under the APA, there's this test you have to be within the zone of interest. And the statute was written in a way that basically precludes anyone from being within the zone of interest. Makes it clear only the president has the ability to enforce this law.
David, can you continue with FCC versus consumer research?
Yes. So the Communications Act of 1934 specifies that there will be all people in the United States will have access to telephone service at reasonable charges. And since 1996, the FCC has outsourced setting the rate structure to a private corporation. And it told that, and the statute from 1996 says, the rates have to be, quote, sufficient to permit, this level of access. And so a case was filed, and there were two primary theories. One was a public non-delegation theory. And it was, I think there was a lot of hope that after the Gundy case from 2019, in which 4 of the conservative members suggested they were sick and tired of the old toothless public non-delegation doctrine where all Congress had to say is public interest, and magically, that test was satisfied, and they indicated a real willingness to go in and overturn that precedent. And of course, now we have 2 more conservative justices on the court. And so everyone really thought, okay, this is going to be it. This case is going to remake the public non-delegation doctrine. And unfortunately, it wasn't a swing and a miss. It was a swing and a foul tip for reasons that I'll explain in a minute. There was also the issue of, wait a minute, why is a private corporation setting the rate structure? And that's the so-called private non-delegation doctrine. The court addressed both of these items. The Fifth Circuit had struck the law down. The United States Supreme Court, per Justice Kagan, addressed these issues. And she, with respect to the private non-delegation doctrine, she said that's easy because the private corporation setting the rates, those rates don't go into effect until the FCC has blessed them. And that is understandable why she would reach that result. And Justice Gorsuch, in dissent, did not take issue with that. Then with respect to the public non-delegation question, she said, look, we've had the intelligible test forever. We're not disturbing that test. The word sufficient gives enough guidance. And so this is an easy case. And candidly, I don't think we'd even be talking about this case on this panel except for Justice Kavanaugh's concurrence.
Yeah.
And what Justice Kavanaugh says is, look, he said, the problem that we're worried about is unaccountable bureaucrats. Unaccountable bureaucrats. And he said, we've done a lot in recent years to rein in the unaccountable bureaucrats. Chevron is gone. The major questions canon is now in place. So we're reining these people in. And he said, this case that comes before us out of the FCC involves a presidential agency. If people don't like what the agency is doing, there's someone they can complain to, namely the President of the United States, who can fire all these people and remove them. He suggested that it would be a different case, and he said he thought it was a case they should take if it had been an independent agency. He said that would be a different matter. Then we would need a non-delegation doctrine that had more teeth to it, and he suggested two possible solutions for an independent agency case. Number one, get rid of Humphrey's executor and just end independent agencies. So that would be quite exciting. The other thing he said was, well, we could say these rules don't go into effect unless they're submitted to Congress. And so it was a fairly short opinion, but he's basically signaling I'm on board with granting cert for a case like this. There were 3 dissenters, Gorsuch, Thomas, and Alito, so that makes 4. So I think you'll be seeing, even though this was a swing and a foul tip, the intelligible principle doctrine lives. It may, there's going to be more in the next couple of terms. I think you'll see another case along these lines.
Josh, the Bradenwood case is yours next.
Okay, so another Obamacare case. It seems we're just cursed, or at least I'm cursed, to cover Obamacare for my entire career. This was a weird one. It was an appointments clause case. There's this task force within HHS that can make recommendations over what drugs Obamacare has to cover. The statute describes these people as independent. Okay, that's an important word that Congress chose. And we describe position independent, that usually means you can only be removed for cause. That is, you have protection from installation. The Obama administration argued that no, these people aren't really independent. They're subject to removal by the secretary. There's a secondary question of how they're appointed, of whether they actually have authority to appoint these individuals. So this case goes to the district court in Texas. The district court finds this statute violates the appointments clause. Again, it goes to the Fifth Circuit. Fifth Circuit finds this violates the appointments clause. But then on appeal, the government kind of changes its theory. They now argue that, well, there's this reorganization plan and it allows the authority to be vested in the secretary. So even though the secretary didn't actually appoint them, he ratified their appointment, this kind of circuitous route. And therefore the court says these positions do not violate the appointments clause. In other words, they're not really independent. Ignore what Congress said. They're not really independent. They're subject to the removal. And then what's curious is that the Trump DOJ continued the Biden DOJ position, which doesn't happen often. Why? Trump wants power to fire people. So this was actually a good precedent for the current administration. Justice Thomas wrote a fairly vigorous dissent saying, whoa, wait a minute. This is not the case that was litigated below, right? The government has changed its theory on appeal. And usually when you do that, you remand to the lower court to consider something in the first instance. But we have to decide this case. The court says we're not going to let it go. I think what we're seeing here in Braidwood is kind of the court's getting tired with these appointments clause challenges. It seems that almost every year we have one of these. We have Arthrex and Collins, and every year there's another appointments clause case, and they never deliver anything, right? It's always, well, okay, there's a problem, we'll just sever this, and everything goes on as usual. The CFPB stays the same, these ALJs stay the same. I think the court's kind of tired of these cases, and they're saying, look, we've done what we're going to do with this. Kagan and the other liberals join this opinion. Enough with these appointment clause cases. I think the bigger story with the Braidwood case, though, is that Obamacare is still generating litigation more than 15 years after it was passed. I've written books on this. This is a law that was drafted very sloppily. The version we have was never meant to be the final version of the law, and they're still using executive action to piece together and patch and rewrite and so on. So this is a law that's kind of an affront to the rule of law in so many ways. It also signals that the Supreme Court likes reversing my beloved Fifth Circuit. Now, in fairness, the Fourth Circuit actually has a worse win-loss record. I think they batted 0 this year. They had 100% reversal rate. So the Fifth Circuit actually did quite better. They were affirmed in a few other cases. But the Supreme Court is truly to the left of the Fifth Circuit. And as we sort of look ahead to the next batch of potential vacancies, I think it's a thing we should just take stock of where President Trump might look to appoint next round of justices. We have track records, we have opinions. And as I like to say, if the last batch of opinions came out differently, Braid would have been affirmed. Consumer research would have been affirmed, right? I can go down the list of cases that would have been affirmed that were not affirmed.
Well, and you can see this administration trying to protect the Fifth Circuit, because I'm counsel in a case called Reese, which involves the Second Amendment and whether 18, 19, and 20-year-olds have Second Amendment rights. And the Fifth Circuit ruled in our favor, invalidated a federal statute, and just a week and a half ago, the Solicitor General declined to file a cert petition and just allowed the Fifth Circuit ruling to stay in place and that federal statute to be invalidated. And so that's one we may see in this administration when the Fifth Circuit does the right thing, particularly with respect to federal law. This Solicitor General may not take those cases to the Supreme Court.
Well, there are a lot more cases, but I want to make sure we have plenty of time for questions. So I'm going to take the moderator's prerogative and ask the first. Every term gives us new insights into the justices themselves, their thinking, their relationships, especially the new ones. So I want to pitch it to each of you, your overarching reflections about the justices, their relationships, their thoughts on doctrines, etc.
Maybe I'll go first and say, you would expect on a court in which you have 6 originalists and 3 left-wing progressives, that if they were looking at constitutional questions, that every case should be 6-3, unless left-wing current radical ideology conforms to what the founders thought, right? And that's not, if we did Venn diagrams, there wouldn't be a lot of overlap there. And and so it's frustrating as a conservative that there are a lot of terms where they're not 6-3, or they're 6-3 the wrong way. There have been frustrations, including in even last term. And this year, when we look at cases like Scribes, we look at cases like Mahmoud, cases like the Paxton case, the porn case, they were all 6-3. They came out the right way. So it was gratifying to see, the 6 originalists doing originalism and reaching in the right result time after time in many of the high-profile cases.
I think one of the stories this term is relationship between Justice Jackson and her colleagues. If you go to oral argument and you actually watch their facial expressions, you see things. And when Justice Jackson starts asking questions, usually Justice Alito kind of covers his face like this, and he kind of just closes his eyes. And seriously, if you look at Justice Kagan, she seems kind of annoyed. It's like, what are you doing, right? We need to recruit conservatives to join us. Why are you going on these sort of tangents? And I think we're seeing a schism. This term, Justice Kagan was in the majority, I think, more than Alito was. Like, that hasn't happened before, at least in my memory. And I think Justice Jackson might be alienating her colleagues on the left. Even just last night, we had this opinion on the shadow docket where President Trump issued an executive order on reduction in force, and the court said, yeah, the executive order is fine. Maybe we'll block it later when he fires people, but the order itself is fine. And then Sotomayor says, well, I agree with the majority. I think Jackson's right in the merits, but this is premature. And Jackson wrote this long 11-page dissent on how this is like the rule of law is falling apart. So I see a shift from Jackson from before Trump to after Trump. She was actually like different last year with she had Trump v. Anderson. She was very, something clicked with her. I don't know what it is. And I think we're seeing the left. And the left can't talk about it. Like, our people, we fight openly. It happens all the time. On the left, they got to keep everything close because they got to be a team. And I think we're seeing evidence of some fracturing on that squad. Squad, sorry.
Yeah, I agree completely with you on that. And I think one of the takeaways for me was that we've seen a lot of this coalition beginning to really pop out, especially with what we were discussing earlier, the emergency docket. Whenever the Supreme Court decides something on an emergency basis, it's oftentimes we see perhaps Justice Barrett, Roberts, Kavanaugh being in the 3 group that is always being sort of the leading sort of focus on where that decision is going to go, whether it's going to be upheld or denied or stayed. And I think that that is fascinating to me because, it was always a question over the last few years of whether Justice Kavanaugh or Barrett was the one that was sort of falling in line more in lockstep with the Chief Justice. And, you always have to look at these things sort of like in a vacuum because each term doesn't define, like where the court is as a totality. But I found it very interesting this term that I believe this is the New York Times that wrote this, and I was trying to align it with what I have seen. They said that Justice Barrett was siding with the government on the emergency applications more than any other justice. I found that to be pretty interesting because a lot of the animosity that was levied against Justice Barrett earlier this year had to do with some of the things like her siding with the majority that did not freeze the $2 billion for USAID and things like that. Justice Barrett, sided, on a couple of matters that really sort of inflamed the right, and but it just so happens that when you take a look at her stats for the term, and you also look at the fact that she wrote the CASA decision. A cynical mind who maybe still is a little skeptical of Barrett might think that that was like a PR move or something that she was.
No one would ever say that.
But I found her to be sort of continuing this streak of what a lot of people out there have said, calling her the most interesting justice. I agree a lot with what Josh Blackman just said about Jackson. It'll be interesting to see if she will continue to sort of be on this island. Or if she'll actually try to win over some of the justices. I think the high mark for Jackson this term was definitely in that what some people called the reverse discrimination case when she wrote the majority in that opinion. I think that she really was able to at least find something that everyone could kind of agree with on that like all discrimination is discrimination. So I'll leave it there.
I'll turn it over to audience questions. If you wouldn't mind raising your hand, and there are microphones, and then please keep your question to a question and keep it short. In the back.
Thank you. So I have a question about a tactic that the lower courts might use in light of nationwide injunctions now being off the table. You've seen in the D.C. Circuit and the Ninth Circuit that they've started to issue preliminary injunctions on a putative class that has not yet been certified. So usually you can kind of pump the brakes on these issuing nationwide injunctions before breakfast because it takes time to certify a class. But they're saying, no, we don't even need to certify the class. We can just issue preliminary injunctions putatively. I'm wondering particularly from Mr. Thompson, who kind of maybe can speak to the civil procedure element of this tactic. Is the court going to sanction this kind of putative prospective class certification?
I think that's highly unlikely. I'd be curious what the other panelists think, but I don't think they're going to get away with putative, instantly made classes. I mean, if they actually certify it, that's one thing, and I think the certifications would then be appealable. I mean, that's the other thing that's very pernicious about what you're talking about, particularly if it's a TRO, which is one of the things they're hiding behind is the lack of appealability of TROs. I think the court is going to stomp that out. But
Well, I mean, in AARP v. Trump, the court signaled that the putative class was okay, right? Because they faulted. Or, in other words, this was the case from Lubbock where the court said the district court didn't grant a TRO in 42 minutes, therefore it's constructive denial. The court signaled relief for putative class. So if SCOTUS can grant relief for putative class, I think lower courts can as well. I think that's a mistake. I've been on this issue for almost a decade. You cannot grant putative classes under Rule 23. That's not a thing. You're just making stuff up. That's worse than nationwide injunction. And the other issue to Jameson's question is these administrative stays. You're having judges in Boston issue administrative stays of spending bills, ordering them to fund Planned Parenthood. She didn't even read the briefs, right? You have TROs being issued in a matter of hours on these massive cases. No one's reading it. So I think the Supreme Court's got to say to the lower court judges, you need to give the government a chance to respond. You can't grant putative classes. It might be for some limited period, people are injured, you deal with it next week, right? I think the court will have to fix this mess at some point.
One thing on that, I think that this is probably, I mean, one could argue that this could be the next area of focus that sort of lands under some scrutiny depending on how things go with, continuing on, with what the Supreme Court advised to lower courts in CASA. If we're seeing a scenario where there's more of this putative class, sort of loophole like workaround, I mean, I think the Supreme Court has sort of inched its way toward higher degrees of scrutiny toward class actions just in general over the last, not even like in the last 5 years, like, going back to like the 2000s and things like that. So I think that, if this is something that is used as a workaround, it might still work, like in the fact that, the birthright citizenship case applies to, uniformly to, hundreds of plaintiffs, thousands of people. But when it comes to, certain matters like funding and grant cuts and things like that, that's something that's way more specific. And I think that if, there was, any sort of, more specificity, added there, like it could, get to the point where it's like, come on, guys, so.
Yes, right there in the front.
Thank you. Following up on Professor Blackman's most recent point, one of the stories I think of this term is the interplay between the Supreme Court and the district courts. Joe Biden put on radicals on these district courts all across the country. We're seeing the Supreme Court lose a little bit of patience with district judges doing all kinds of crazy things, whether it's in Massachusetts or District of Maryland with this standing habeas order or, all kinds of different problems. What are some things that the Supreme Court could possibly do to remedy this issue of district judges just trying to run out the clock on the Trump administration or just acting in bad faith? I know that Article 1 can do some stuff, but the Supreme Court itself.
I think, you're going to see a few things, Ethan. Number one, obviously, we're seeing reversals. That's good. We're seeing them taking cases on an expedited basis. The CASA case was very expedited. I think the argument was in the middle of May, which they generally don't do. But the other thing that eventually I think will happen, and I believe the Department of Justice has even requested this in one case, is removing the district court judge from that case. In my career, I can only remember one instance where we asked for that and it was granted to us. And it was just an out of control district court judge. It's the most insulting thing that a court of appeals or the Supreme Court can say to a district court judge is, you have acted in a way that that we are deeming you incapable of being neutral, incapable of following your oath of office. And I think the chief and the others are going to start deploying that if we continue to see basically contumacious behavior that is in contempt of court and would land them in prison if they were litigants.
Yeah, I mean, Ethan, you work in the branch that actually could fix this, right? So I think Congress needs to take action, in theory. Congress should take action. I like 3-judge panels. I like automatic stays. I think there are ways that Congress can intervene because lower court judges, again, I can't stress this, you can't grant an ex parte TRO without reading the briefs. At least pretend to have sat on it overnight before you grant a TRO. Robert says the remedy for bad judging is not impeachment, it's the appellate process. Okay, so the court has to reverse things quickly, right? You can't have these rulings on the book for days on end.
And Josh, you may know more about this than I, but I read a post a few months ago that suggested this rule that TROs aren't appealable.
Not a real thing.
It's not a real thing.
Not a thing.
And so they need to fix that too, because that's what you're seeing these district court judges trying to immunize themselves. And that's why you hear about things like impeachment, because typically we think, okay, well, when there's a district court judge who does something crazy, they get reversed. Well, now they're trying to immunize themselves from being reversed, and they're invoking a doctrine that isn't a real thing.
Yeah.
John, here in the front.
I thought the most remarkable thing about the CASA case was John Sauer's admission that that the opinions of the Supreme Court bind the president. I was shocked. I was in the courtroom. Can any of you tell me whether that's going to last? Is he going to be contumacious? Are they going to fire? Is that going to hold through the whole Trump administration? Or do you have any other comments on it?
Yeah, not good. So, hi, my name is Josh. I'm not a judicial supremacist. John Sauer, unfortunately, was, right? It's never been said that the president's bound by the Supreme Court's decisions. The judgments, sure, but not their decisions. Cooper versus Aaron, which is one of the worst decisions in American history, said that lower state officials, governors, are bound by the Supreme Court's decisions. Wrong, but not terrible. But the president is a co-equal sovereign, a co-equal branch of government. The Supreme Court's not above him. And unfortunately, Chief Justice Roberts is like, okay, cool, that's me, right? John Roberts is not above the president's not above John Roberts. We have equal branches of government. In fact, the courts are they're least dangerous. So that was a really bad statement from Sauer. I think he had to make it for that case. Maybe he didn't, but he decided to. And that will be cited against the president for generations to come, unfortunately.
Yes, here in the front.
Who had that?
The Supreme Court in England came out flat and said that there are two sexes. Are there any cases headed toward the U.S. Supreme Court where they might rule similarly?
Kaylin, I think.
Yeah, I briefly mentioned on this, and while it's unfortunately, I would love if it was more of a direct, reference to your question. It's going to explicitly target more of the, sports issue that we've been talking about for years and years now. And again, that's in the West Virginia versus PPJ case that's going to be argued in the next term, likely a decision by 2026 on this. And it's going to be more implicating Title IX and the Equal Protection Clause, whether those, entities sort of have any bars or holds on males competing in, female sports, girls' sports. And I think that this is something that, the way that some of these laws, especially West Virginia, are constructed is that it essentially is on more of like a fairness grounds. Like when it comes to, obviously we know that if a male is competing against a girl, they're going to win, 99% of the time, with different physical attributes, things like that. And I think that that's something that the Supreme Court is going to be, looking at meticulously here is like, is this actually, discriminating, against, other people, other genders, or is this actually something that's, more so in line with ensuring that we still have women's sports, like going down the line,
I think the sports cases are going to be helpful because the premise of them is you are born a man, and whatever you say, whether you've been radicalized by Montgomery County or somebody else, nothing changes the fact that your chromosomes remain as they have always been, and that can never be changed. And there are two types of people, those with the X and the Y and those with the X and the X, and that's it. And that's going to be a premise of that decision. So I think it's going to be helpful on that point.
We have time for one more question. Yes, right here.
Thank you. You talked about the increasing caseload on the emergency dockets, and I'm not an expert on American constitutional law, but do you think the Supreme Court should have accepted all those emergency applications, or he should have rejected some of them?
As with the last comment, I think we're just about out of time. I think the court needs more cases. The docket is shrinking. They're writing these really long concurrences that no one reads. Decide more cases, write less.
Well, we actually have time for one last one if it's a short one. So if we have any, yes, there's a hand just here.
I have a question. The Supreme Court is changing a lot of past decisions. Given that, can a decision in the state court or in D.C. Superior Court which violates the civil and human rights of a defendant or a plaintiff, can they be sued? Can the state court be sued in federal court? And will the Supreme Court allow such a thing?
I have represented the justices of the Supreme Court of West Virginia several decades ago. So occasionally judges are sued. I also represented the justices of Arkansas recently in a case. So you'll see judges get sued every now and again. They generally have immunities. And at least in the case of the Arkansas Supreme Court, when an out-of-control district court judge was going to allow all of the emails between the judges and their law clerks to be subject to discovery and made public, the Eighth Circuit leaped in, granted mandamus, and flushed the entire case. So the bottom line is you may see it, but I think it's extremely unlikely to work.
Well, that's the end of our program. Please join me in thanking our panelists.